Welcome back, my dear students. Today we will learn the drafting of a plane under Order 37 of CPC. You are supposed to draft a plane or a suit in a summary manner in accordance with Order 37 CPC. Before you dwell upon the actual exercise of drafting this plane, you should know the pecuniary original jurisdiction of civil courts in the state where you are practicing, maybe Delhi or UP, because different states have different pecuniary original jurisdiction of civil courts. So you should know the hierarchy of courts and their pecuniary original jurisdiction. Here is the list of books. You can pick up any one of these books for learning this draft. Now, so far as pecuniary original jurisdiction of civil courts in Delhi is concerned, Civil Judge Junior Division can decide cases up to rupees 10 lakhs. Civil Judge Senior Division can decide cases above 10 lakhs up to 25 lakhs. District Judge can decide cases of original jurisdiction above 25 lakhs, extending up to 2 crores, and High Court has unlimited jurisdiction. Now, so far as the original pecuniary jurisdiction of civil courts in UP is concerned, initially, Civil Judge Junior Division had jurisdiction of deciding cases only up to 25,000 rupees, but now it has been raised up to 3 lakh. Civil Judge Senior Division has unlimited jurisdiction. District Judge, including ADJs, they also have unlimited jurisdiction, and High Court, of course, has appellate jurisdiction. Now, what is the difference between a suit which you are going to draft under Order 37 and other ordinary suits? You should know this distinction first. Dear students, in ordinary suits, defendant has a right to contest the suit. Summons are sent to the defendant for filing of WS and framing of issues. After pleading of the parties, issues are framed by the court. Then both the parties are given right to give their oral evidence. After close of evidence of both the parties, arguments of both the parties are heard, and then a judgment is pronounced. This is a normal and lengthy procedure of a trial of a civil court. No leave to defend is to be applied by the defendant in ordinary suit. Every defendant has a right to contest the suit. Second point is that a plaintiff enforcing negotiable instrument may either bring a summary suit or he may file a regular original suit in ordinary manner. Under Indian Limitation Act, a summary suit must be brought within 1 year from the date when the debt became due and payable. But under the same act, the period of limitation for filing ordinary suit based upon negotiable instruments is 3 years. Dear students, summary suit can only be filed in the courts mentioned in Order 37 Rule 1 CPC. Summary suits can be filed in the high courts, city civil courts, and court of small causes and other courts authorized by the respective high courts. So we have to see the points of distinction between the two kinds of suits, that is an ordinary suit and a suit filed under Order 37. Under Order 37, the suits are filed, they are known as summary suits, or summary procedure is provided under Order 37. Summary procedure is applicable in following classes of suits. It's not applicable to all suits. Number one, suits based upon bill of exchange, hundis, and promissory notes. This means that all cases based on dishonor of check and then consequent recovery of money based on promissory notes, these cases can be filed under Order 37 in a summary way. And second category is suits for recovery of a debt or a liquidated demand of money in a fixed sum. These two categories of cases are allowed to be filed under Order 37. Then the distinction which I told you in the beginning is that in a summary suit, you have to obtain the leave to defend from the court. The defendant is not entitled to defend the suit in such cases unless leave to defend is granted to him. Summons to defendant are sent in form number 4 of Appendix B attached at the end of CPC, along with a copy of the plaint and annexures thereto. In such cases, summons are first sent to the defendant for his appearance in court. That if the defendant fails to appear before the court within 10 days of service of summons, the allegations mentioned in the plaint shall be deemed to be admitted, and the plaintiff is entitled to a decree for a sum he has claimed in the plaint. Secondly, the defendant has a right to appear before the court. If he appears, he shall file an address for service of notice on him for future. See, it is a duty of the defendant. He shall appear and file an address for the service of notice on him for future, because maybe that after receiving this summon, the defendant might change his address. So on the day of entering the appearance, the defendant will give notice of his appearance to the plaintiff. See, first of all, the plaintiff had sent notice to the defendant for appearance in the court. Now on appearance, defendant will give notice of his appearance to the plaintiff. And on appearance of the defendant, again, plaintiff will serve upon the defendant a summon for judgment. That is form number 4A of Appendix B. Returnable not less than 10 days from the date of service, supported by an affidavit of plaintiff, verifying the cause of action and the amount claimed, and stating that in his belief, there is no defense to the suit. Now, the defendant may at any time within 10 days from the service of such summons for judgment, by affidavit or otherwise, disclosing such facts as may be deemed sufficient to entitle him to defend, apply for leave to defend such suit. This is the main distinction, dear students, that on appearance, the defendant will have to apply for leave to defend such suit. Leave to defend may be granted to the defendant if he can satisfy the court by affidavit or otherwise that he has a defense to the suit on merits, or that it is otherwise reasonable that leave to defend may be granted to him. This leave to defend may be granted conditionally or unconditionally. If the defendant has admitted a part of the claim, leave shall not be granted to him unless the amount so admitted is deposited in the court. Obviously, when defendant is admitting the claim of the plaintiff or part of it, then he should deposit that amount in the court first and then ask for leave to defend. And if the defendant does not apply for leave to defend, or he applies and leave is refused, then plaintiff shall be entitled to judgment forthwith. If the defendant is permitted to defend, court may require him to give such security within such time as may be fixed by the court, and on failure to give such security, the plaintiff shall be entitled to judgment forthwith. You see, existence of a tribal issue is a backbone of entire procedure of summary suits. If in the opinion of the court, there is a tribal issue, only then leave to defend shall be granted. Otherwise, leave shall be refused, and plaintiff is entitled to the judgment then and there forthwith. The object of summary suits, my dear students, is prescribed in Order 37 itself, and the main object of Order 37, prescribing summary procedure, is that small matters are not unduly delayed by untenable pleas in defense, mainly because of legal presumptions arising from documents filed by the plaintiff. But at the same time, when defense raises a tribal issue, then he must be afforded reasonable opportunity of hearing. So the net conclusion is that in a summary suit, if leave to defend is granted, suit will proceed like an ordinary suit and defendant will file his WS. But if this leave is refused, then the judgment shall be pronounced in favor of plaintiff forthwith, no long procedure. Hence, it is known as summary procedure for summary suits. Now I'm giving you summary of summary suits once again. Number one, only selected courts are authorized to conduct summary suits. Selected subject matter summary suits can be filed. Institution of suit is there. Plaintiff will institute his suit by filing of the plaint. Then copy of the plaint is to be sent to the defendant along with summons. Defendant may enter on his appearance. Defendant to file his address for service. Then defendant to give notice of his appearance to the plaintiff. Then plaintiff to serve summon for judgment in form number 4A of Appendix B of CPC. Plaintiff to send his affidavit along with this summon. Then defendant to apply for leave to sue within 10 days of receipt of the notice. Then leave to defend. If refused, then plaintiff is entitled to judgment in his favor. And if leave to defend is granted, then court may take security from the defendant. If leave to defend is granted, then of course defendant will file his WS and case will proceed like ordinary suit. If part of the claim is admitted, then leave to defend will be granted only on deposit of such amount by the defendant in the court. So dear students, with this much background in mind, now let us start the actual drafting of a summary suit. First of all, you will have to select the name of the court. So in the Court of Civil Judge Junior Division, New Delhi, suit number dash dash of 2017. Because why you have left the suit number as dash dash? Because you do not know the suit number. You have drafted this plaint while sitting in your corporate office. And secondly, the suit number shall be allotted to you only after filing of the suit by the staff of the court, or if it is a case of e-filing, then computer generated suit number will be given to you. Now then, next heading you will write down ordinary original civil jurisdiction, and in the bracket you will mention a suit under Order 37 of CPC. This heading is essential so that the court may come to know that you have filed a suit under Order 37. You want to file a summary suit. You want a summary procedure for its decision. Then the name of plaintiff and defendant are to be mentioned with complete name and address. In our illustration, Messrs. ABC Private Limited is the plaintiff and Messrs. XYZ Limited is the defendant, and their complete address is to be mentioned in the plaint. Then heading you will give that suit for recovery of 1,94,380. See, the valuation is well within the jurisdiction of Civil Judge Junior Division, New Delhi. So this is a suit for a definite amount. Hence, summary suit can be filed under Order 37. Now, beginning is to be made like this, that the plaintiff above named most respectfully showeth as under. Para 1, that the plaintiff is a company constituted under the Companies Act, having its registered office at B40 Safdarjung Enclave, New Delhi, Mr. P, Executive Director of the company, is a duly constituted attorney of the plaintiff company and is authorized and competent to sign and verify the plaint, wakalatnama, etc., and to institute this suit on behalf of the plaintiff. So para 1 is telling you how plaintiff is authorized to file this summary suit. Para 2, that the plaintiff company inter alia carries on the business of construction, engineering and design. The plaintiffs are the builders of international repute and have earned a big name in their business. Para 3, the defendant is a company incorporated under Companies Act having their registered office at Chandigarh. However, the administrative office of the defendant is situated at 72 Roopnagar, Delhi, within the jurisdiction of this honorable court. Para 4, the defendant approached the plaintiff for construction of a building for their paper mill at Chandigarh in June 2015, whereupon the plaintiff constructed the building and handed over the possession of the same to the defendant sometime in December 2016. So the building was ready. Para 5, that on 4th April 2017, plaintiff raised the final bill of rupees 1,39,492 rupees after adjustment of all previous payments by the defendant on account of aforesaid construction of their paper mill at Chandigarh, against which the defendant handed over a check dated 4th April 2017, bearing number 213456 for rupees 1,39,492, drawn on Punjab National Bank, Shadra, Delhi, to the plaintiff, which was dishonored on presentation. So, dear students, please note that this suit is being filed because the check given by the party was dishonored. So, this is a suit based on negotiable instrument, hence summary suit is allowed. Para 6, the plaintiff immediately informed the defendant about the dishonor of the said check and called upon the defendant to make the payment of the said amount along with interest at the rate of 18% per annum. However, the defendant failed to pay the same to the plaintiff despite repeated requests and reminders. Para 7, the plaintiff therefore finally issued a legal notice dated 6 April 2017 to the defendant, calling upon the defendant to clear the outstanding amount of rupees 1,94,318 along with interest at the rate of 18% per annum with effect from 4th April 2017 up to the date of payment. But no payment has been made by the defendant despite the said notice. Para 8, defendant is not liable to pay a sum of rupees 1,39,492 along with interest of 18% per annum from the date of the plaintiff's bill. The plaintiff has, however, claimed interest from 4th April 2017 up to the date of filing of this suit at the rate of 18% per annum, which comes out to be rupees 54,826, thus making the total liability of the defendant at the time of filing this suit to rupees 1,94,318. Ninth, the cause of action in favor of the plaintiff and against the defendant first arose in June 2015 when the plaintiff was approached by the defendant for construction of their paper mill. It further arose in December 2016 when the said building was completed and handed over to the defendant. And again on 4th April 2017 when the plaintiff submitted the final bill to the defendant. Then cause of action arose on all these dates when the plaintiff called upon the defendant to make the payment and the latter failed to comply with it. And the cause of action is still subsisting as the defendant has failed to pay the outstanding amount despite repeated oral and written requests and reminders from the plaintiff. Para 10, The suit is filed well within period of limitation. Para 11 relates to jurisdiction. It is to be drafted like this, that this honorable court has jurisdiction to entertain this suit because the part of the cause of action arose at Delhi, and because the contract for construction of the paper mill was entered at Delhi, all the payments up to this date have been made at Delhi, and the payment of the outstanding amount was also to be made at Delhi. And because the administrative office of the defendant is situated at Delhi, where they carry on the work for their gains. Now, valuation. The valuation of this suit for the purposes of court fee and jurisdiction is rupees 1,94,318, on which proper court fees has been paid. Para 13. That this suit is filed under Order 37 of the CPC and no relief has been claimed, which does not fall within the ambit of Order 37. The suit amount is a liquidated sum of money payable by the defendant to the plaintiff under check number 213452 dated 4th April 2017 for rupees 1,39,492 drawn on Punjab National Bank, Shadra, Delhi, which was dishonored upon presentation along with interest. Now, prayer clause. It is therefore most respectfully prayed that this honorable court may be pleased to pass a decree for rupees 1,94,318 in favor of the plaintiff and against the defendant. Be relief, award pendentialite and future interest at the rate of 18% per annum on the above stated amount of rupees 1,94,318. See, dear students, the interest has been calculated up to the date of filing of the suit. But you want interest pendentialite means that interest during pendency of the suit, and future interest also till the money is paid to the plaintiff. See, relief you want, court should award cost of the suit in favor of plaintiff as against the defendant and pass such order or further orders as may be deemed fit and proper in the facts and circumstances of the case. Now, as usual, you know every plaint is to be signed by the plaintiff, and since this suit is to be filed through some advocate, so you will write down the name of the advocate also through Mr. N.O.P. Advocate. He will also sign this plaint. Place of signing this plaint will be mentioned as Delhi, and date of signature is also to be mentioned. Date of signing the plaint is 1st August 2017. Now, lastly comes the verification clause. The plaint is to be verified by the executive officer of the plaintiff company. So, I, P, the executive director of plaintiff company, do hereby verify that the contents of para 1 to 8 of the plaint are true to my knowledge, derived from the records of the plaintiff company maintained in the ordinary course of business, and those of para 9 to 13 are true from information received and believed to be true, and the last para is humble prayer to this honorable court. Lastly, where you have verified this plaint, you are supposed to draft it also, verified at Delhi on this first day of August 2017. After verification, again, the signature of plaintiff are required, and the signature of advocate who is filing this plaint are also required. So you will write down through NOP advocate, and his signatures are to be appended on the plaint. So, dear students, this is how a suit or a plaint relating to summary suits under Order 37 for adopting summary procedure is to be drafted by you. And the main distinction I am repeating before I close, that in summary suit, the plaintiff has no right to contest. He has to obtain the leave of the court for contesting this summary suit. If the leave to defend is granted, then of course the suit will proceed like an ordinary suit. He will file WS, then issues will be framed, then evidence of parties will be taken, arguments will be heard, and judgment will be pronounced, and then a decree shall be drawn. That is a normal procedure of a civil suit. But if leave to defend is refused, then that is a striking feature of this Order 37 summary suit, that plaintiff is entitled to judgment then and there in his favor. Since the court has come to a conclusion that the defendant has no tribal issue and he has no difference to make. So, in such circumstances, summary suit can be filed. So, dear students, thank you very much